5 seconds to go. Start. At the cost of repetition, it is observed that as per the incentive policy declared by the state government, the power generating company was put in the list of ineligible industries and thus independently was not entitled to the exemption under the original entry number 255-2. Thus, by such a transfer sale from the eligible unit to another unit, the benefit of exemption is availed by the ineligible industry, which is wholly impermissible and that cannot be said to be the intention of the government while providing the incentive in the form of exemption from payment of purchase tax. Such a benefit of exemption was available is concerned, the aforesaid has no substance. In the relaxation matters, every assessment year period is a different year period. The scheme of the statute does not in any manner indicate that the incentive provided has to continue for the consecutive years irrespective of the fulfilling of the eligibility conditions. Applicability of the incentive is directly related to the eligibility and not dehors the same. If it is found that the industrial undertaking does not fulfill the eligibility criteria, it cannot claim the incentive exemption. Therefore, the submission on behalf of the respondent assessee that as in the earlier assessment years, benefit of exemption was granted to the respondent and therefore, in the subsequent assessment years also, despite the fact that it is found that the respondent is not eligible for the benefit of exemption under the original notification entry number 255-2 cannot be accepted. If such a submission is accepted, in that case it will be perpetuating the illegality and granting the benefit of exemption to ineligible industry who did not fulfill and or comply with the eligibility criteria conditions mentioned in the exemption notification. The principle of promissory estoppel shall not be applicable contrary to the statute, merely because erroneously and or on misinterpretation some benefits in the earlier assessment years were wrongly given only to eligible units industries and the steel industry of which SR Steel Limited belonged being one of the eligible industries. Therefore, there was no question of applicability of principle of promissory estoppel. Even otherwise, in the facts and circumstances of the case narrated herein above, the principle of promissory estoppel shall not be applicable. ESL had furnished wrong and false declarations. In the original notification entry, it was not provided that even if the raw materials so purchased is not used by itself after availing the exemption, the same can be sold to another entity which is ineligible industry. It did not provide that in such a situation also, and despite the fact that raw material is not actually used by the eligible unit which was required to be used, even as per the declaration in form number 26, such eligible unit shall be entitled to the exemption. No such promise was given. The wordings and the language used in the exemption notifications are very clear, simple and unambiguous. Therefore, when there was no such promise and or representation, the demand cannot be said to be hit by the principle of promissory estoppel as observed and held by the tribunal as well as the High Court in the impugned judgment and order. Stop.